A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. Hopefully you had a great weekend and your Monday is going well. We're going to be talking with Mark Walters, host of Armed American Radio, here in just a moment or two. Sort of it's at least a semi Monday tradition, Mondays with Mark. And this morning when I was hitting refresh on the Supreme Court website, starting about 9:28 in the morning, just in case they dropped this week's orders list a little early, I thought, you know what? I want to talk with Mark. No matter what happens with Snope this week, I want to talk with Mark Walters about it. So I texted him, said, hey, can you hop on? He got right back to me, said, absolutely. And then the orders list came out, and once again, no news on Snope. No news on Ocean State Tactical, which is the challenge to Rhode Island's magazine ban, which has also been heard in conference for the umpteenth time, or at least scheduled to be heard in conference for the umpteenth time. No news on either one of those cases, which is news in and of itself, right? At this point, because these cases have been relisted so many times, going back to mid-December of last year. It is almost April now, and we still don't know what's going on. That is newsworthy in and of itself. So I wish that we had some facts to discuss, but the facts are few and far between. The facts are that these two cases continue to get listed to be heard in conference, and then nothing happens, and they get relisted again. Those are the facts. Everything else is, I would say, mindless speculation, semi-informed speculation, perhaps, but certainly enough to have a good conversation with, and Mark Walters providing the other half of that conversation about what the Supreme Court might be doing with the semi-auto ban out of Maryland, with the Rhode Island magazine ban. Take a look and a listen. Mark, good Monday to you. Thanks so much for being a part of the program.
Pleasure to be here with you on a Monday, Cam. How are you?
I am good. I feel like it's kind of like Groundhog Day. Costas Moros, the Second Amendment attorney who works with Chuck Michelle and Associates, actually every Monday posts a little a meme of him as Bill Murray in Groundhog Day saying, no news on Snope. And once again, pardon me for the rooster in the background. Once again, we did see an orders list come out. Ocean State Tactical, not listed. Snope, not listed. All right, we are now almost to April, Mark. These cases first got heard in conference in mid-December.
Yeah.
So I'm not going to ask you what's going on because I know that you have no idea any more than I do. Mm-hmm. But let me ask you this. Are you feeling more pessimistic or more optimistic now we've gone yet another week without any news from the Supreme Court?
Let me take my glasses off on that one real quick and have a sip of coffee.
Yeah, rub your eyes if you need to.
Yeah, I'd be lying if I told you anything other than I'm really tired today. Sundays are long days for me. Mondays I treat like Fridays. And for some reason last night we didn't get done with all the post-production work on the show. Last night's big monster cast until 3 a.m.
Oof.
It happens from time to time. So let's revisit that Snopes, because this is like, and I'm going to use the analogy, it's almost like an emotional roller coaster ride at this point, right? The first 3 to 4 times this thing went up to conference, there was a little bit of trepidation there. Why aren't they hearing this? Why aren't they granting cert on this? They've already, as we've talked about almost ad nauseum together over the last year on this, you're 4 conferences into this. You've already GVR'd this. You've granted it. You vacated it. You remanded it. You waited for the 4th. The 4th comes back after jerking around and playing games. All this time goes by. It's a perfect case. It checks all the boxes. What is the problem here? Well, I get to talking with Mr. Gottlieb about these things at Second Amendment Foundation, who knows the system probably better than anybody else as far as the courts are concerned, particularly SCOTUS. And he says, we never know the answer to that question. However, because they don't tell us.
Right.
He said, but I believe that it's just a timing thing. It's a docket issue. So they just keep pushing off. Then you get to 5 times and 6 times. And my comments to Alan on my show were, I feel better about this now than I ever have before because they've had ample time to deny cert in this case, Cam. Ample time to do this.
Mm-hmm.
And they haven't. So the longer this drags out, the better it is. Then we go to the 8th time, right? And Gottlieb tells me on air that his 90% is now down to 80%, okay? He's now beginning to feel, after talking to a couple constitutional scholars who follow the Supreme Court, attorneys whom I won't mention, said there's history at the Supreme Court in things like this, where this could be a signal that there's a dissent. And that's why there's a delay here. But a dissent on which side? We don't know the answer to that.
Yeah.
Now we go again to this is clearly going to be up for conference again. We don't know a date. Hopefully we find out it's this Friday. We'll get that information this week. But now I'm swaying back to even more confidence than I had before as this drags out to 8 times, 9 times, 10 times. Again, I go back to ample opportunity to deny cert in this case. How long is a dissent going to take?
Right.
If in fact there's a dissent. Now, ladies and gentlemen, we're talking about a dissent, which in this case would be as to why the case may not have been heard. Okay, why did they not grant cert? Why did they deny cert in this case? And you might get a lengthy dissent on that. And I feel certain that if that were the case, Thomas would more than likely write that. After reading Kavanaugh's concurrence in Vanderstock, I don't know if he's ever going to get a majority opinion written. That was the worst thing I've ever seen, but I'll digress there for a moment. That's another conversation. So, I had publicly stated that I felt my confidence level dropped to about 75%. I'm feeling it go back up again. It's just a weird range of emotions because we're trying to second guess a court and a conference that we will never understand unless we're there. So we'll never know the answers unless we get a dissent. Then we'll know we're right. But I will say this, if the case is granted cert, I feel 100% confident we win this case. That much I will tell you.
I agree.
So,
I agree with that. And I also agree with you too about the roller coaster of emotions, right? And it does kind of vary from week to week. So there are a few possibilities, right? They could grant cert. They could deny it with or without a written dissent. There's a possibility of a per curiam opinion, a unanimous decision. We saw that in Catano, where the Supreme Court said that, stun guns are protected by the Second Amendment. I suppose it's a possibility. I really don't see like Justice Jackson coming out and saying, yes, AR-15s are protected by the Second Amendment.
That's not going to happen.
Right. So I put that at about 3% chance, right? But, you go back to something you said about the timing and what Alan Gottlieb said about the timing. So we've seen both cases, Snope and Ocean State Tactical, relisted. Ocean State Tactical is a challenge to Rhode Island's magazine ban. Unlike Snope, it has not been fully decided, right? That is, it is an interlocutory appeal. So they're basically appealing the denial of an injunction rather than, okay, this case has been fully decided. It went up to the appellate court, got fully decided there. Now it's going up to the Supreme Court. You look at Duncan. That's the case out of the Ninth Circuit, California's magazine ban. The Ninth Circuit just upheld California's magazine ban. Yes. So the next stop for Duncan is going to be the Supreme Court. And there's a part of me that wonders, like, there's no deadline for the justices to agree to take a case. They could hold Snope for a year and hear it in conference every week for a year, right, before they decide to do something with it. So there's a part of me that's now wondering, are they waiting for Duncan to get up there and take Duncan and Snope at the same time? The only thing is, why are they hanging on to Ocean State Tactical? Unless maybe they're going to hold on to it and then GVR it, or just deny it.
Let's explore that because there's magazine bans in each of these in each of these cases. It is, Ocean State Tactical. Maybe they're pushing that off to the side to see what they decide, whether or not they bring the Ninth Circuit case in to Snopes. Now they've got another case they can look at or review. They could tie all three together. We don't know what the court is going to do. Yep. And we won't know why, really, until we get a decision in the case. Once we get a decision, if they grant cert in any case, hopefully it's the Fourth Circuit Maryland Snopes case. When we read that decision, we'll know. We'll be able to discern why it took so long, I think. That's as close as we'll ever come. But this is fascinating for a number of different reasons. I personally have never seen anything like this on a case that has been GVR'd like this, where, as you mentioned and you point out, that this case has already been adjudicated.
Yeah.
The Fourth Circuit, the full Fourth Circuit, has already adjudicated this case and upheld it as constitutional. So again, this goes back to, you circle back to use Jen Psaki's little things, just let's circle back here. That's what makes this the perfect case. every step in here, again, it checks every single box that there is for a SCOTUS case.
Mm-hmm.
Now, the Ninth Circuit case, and I think any of these cases are winnable for us at Supreme Court, but it is the Snopes case, I think, that is the Mac Daddy. That's the Mount Everest of these cases right now. Clearly, we're not going to get a decision on this summer. It's possible. Talking with Gottlieb, it's possible, but I doubt it. It's going to be next term. Who knows? Who knows? These are the things that frustrate me and a lot of our viewers is we want things to happen today, right? These are very important issues that need to be decided. Well, the wheels of justice spin very slow. I happen to know that from personal experience. And, there's nothing you can do to push this any further than it is right now. The court makeup appears to be on our side, although I was a little concerned in reading Vanderstock in the three concurrences, particularly Kavanaugh's concurrence.
Yeah. Just to jump in, the one thing that makes me feel better about Kavanaugh when it comes to a semi-auto ban is, when he was on the D.C. Circuit Court of Appeals, he was in the minority, but he ruled against Washington, D.C.'s ban on so-called assault. And so he at least has a history. That would be it would be a change in mindset for Kavanaugh to now say, AR-15s aren't protected. So as squishy as his concurrence was in Vanderstock, giving way too much deference to the ATF, not to abuse its authority, as squishy as he was in Bruin, with his concurring opinion, I feel okay about Kavanaugh on a semi-auto ban. To me, it's Barrett that I'm a little concerned about on a semi-auto ban. It should
be. Her concern for Barrett should be, because we're getting to see some signs. Now, this is going to take a number of years and a number of cases to watch this play out before we can make a definitive statement about where Barrett is. But there are some unsettling indications that Barrett is moving more, or maybe already has been a little bit more moderate than we thought on a number of issues, not just the gun rights issue, but a number of issues that conservatives hold dear. How is that going to play out? We'll stay focused on the gun cases right now. She has a history. I believe she's pro-gun. And I believe she'll rule the right way. I would not certainly put her in the camp with Sotomayor or Kagan or in any way with Jackson in any of that camp. But is there a possibility? This is something that we didn't talk about. Is there a possibility in conference right now that the justices are not confident that they have that majority vote on the court, and that's why they continue to push this off? Are they continuing to talk to this particular justice before they take? We don't know the answer to that.
Right.
But that is obviously a potential option here. Could it be a Barrett? I don't know. And I agree with you on Kavanaugh. He was very sketchy in the Vanderstock ruling. He gave way too much deference to the ATF. And I don't know if it was naivety or stupidity. You don't ascend to the Supreme Court as a stupid individual. So I'm going to assume there's some naivety there, but that shocked me in and of itself, where the government, as he mentioned in Vanderstock, well, they've already told us, the Solicitor General already told us that they're not going to prosecute people under these terms. And even if they did, well, that person will have due process. Okay, after their life has been wiped out, their savings are gone, they're bankrupted, and they've had to live with this for years in a court battle. And I got to thinking, is Kavanaugh that naive to where has he been for the last 8 years, particularly the last 4, while the ATF has been harassing and doing just what he says? He trusts the Solicitor General when she says they wouldn't do it. They've been doing it. So, move that to a case like this. Could he change an opinion? Could somebody have gotten to him? We just don't know. It's all up in the air, but it's fascinating to discuss. Eventually, we're going to find out. That much I can tell you for certainty.
Right. Absolutely. My rooster agrees with you, by the way, Mark. That is a crow of approval, if you can hear that in the background. My sense is that Kavanaugh is an institutionalist. And by that, I mean that, he respects these institutions perhaps more than they should be respected. Because you look at, Bruin, and he talked about, I think it was footnote 9, where, basically licensing regimes are okay. Yes, you might have some that run afoul of the Constitution if there are excessive delays or excessive fees. But again, the deference is given at the get-go to these licensing authorities, right? That they're not going to abuse your rights. And I think we saw sort of that same attitude in his concurrent opinion of Vanderstock that, yeah, it's possible, but let's give him the benefit of the doubt, right, that they're going to play on the up and up. Again, I don't know that that's naivete as much as it is maybe respect for those institutions. Whether that respect is deserved, again, I think very much an open question. But as you say, ultimately, we aren't a fly on the wall. We have not seen any leaks from the Supreme Court on this particular case.
Yeah, right.
I'm ready to see a draft opinion, quite honestly, leak out, but I don't know that we're going to get one. And it does come down, right? It takes 4 justices to agree to hear the case, takes 5 to win. On paper, I feel very confident about Justice Gorsuch, Justice Thomas, Justice Alito. As I said, Brett Kavanaugh in the past has declared that semi-auto bans are unconstitutional. So that should be your 4, right, to hear the case. But then again, so what's the hang up here? Is it that those 4 individuals are concerned about where Justice Barrett, where Chief Justice Roberts might be on this issue?
Well.
Right.
Could be Roberts as well. Look, Roberts has voted with us in every major gun case since he's been on the court.
Yep.
So do I fear Roberts at this point? No, I don't. Because he has that history on those 3 cases. Barrett, I would be a little bit more concerned about because she doesn't have that lengthy history. One thing that concerns me about the Fourth Circuit ruling, you've got the entire Fourth Circuit that ruled on this case, right?
Yeah.
And this is now, when you look at the overall, we don't have enough time to get into it, but let me put it this way. It should be a 9-0 decision, quite frankly. But the Fourth Circuit gave what might become, or what they knew might become, the at least 3 dissents on that case if it's granted cert. That would be Sotomayor, Kagan, and Jackson, a blueprint for their dissent. That's what that Fourth Circuit gave them. All right. That's why it's not going to be a 9-0 decision.
Mm-hmm.
You can take that to the bank. And I can promise you they're going to refer back to that Fourth Circuit opinion in any dissent should this case be granted cert. So the whole thing is fascinating. And like you, I get frustrated every Monday, and Friday, I wonder what's going to happen on Monday. What are we going to get when everything pops out on Monday morning? And here again, it's just another weight. It's almost like we're being head faked out here, but the court will take its time. We've known this over the years. It really doesn't matter what the topic is. They will take their time. We are, as you said, we're not the fly on the wall. Would love to be in this case. Well, I'd love to hear. It's possible that this hasn't even come up in conversation yet in conference.
Right. Yeah, they just keep. You're right. Absolutely. Yeah, it's because we know it's scheduled to be heard in conference. That doesn't mean it actually gets heard in conference. Mm-hmm. Right. No, that is actually a really good point. And it might explain, frankly, that might be the simplest explanation for why it keeps getting relisted, because they really haven't discussed it in detail yet. Obviously, this is an important topic for us, but there are a lot of cases that the Supreme Court deals with every week. And this doesn't mean they may say, hey, listen, we've got, these other cases percolating. We can hold off. We can put this on the back burner. Again, we don't know. But one day, Mark, we're going to find out. I don't know when that day will be, but one day we're going to find out.
Oh, just ladies and gentlemen, pray for cert. We get cert, we're going to win this case hands down. And I believe it will it will be at least a 5-4. It's going to likely be a 6-3 decision. And I think we'll win it. It should be a 9-0. It's pretty much a cut and dry case. But again, that Fourth Circuit, if you're a liberal, and I'm not, hard to get in their heads, really laid out a blueprint for the dissent in this case. But as Jackson pointed out in her concurrence in the Vanderstock case, the dissents don't matter. It's the majority opinion. And that may have been Sotomayor that wrote that. I think it was Sotomayor, but one of the two wrote that. The dissents don't matter. Yeah. It's the majority opinion that matters. I'm kind of curious, shifting gears to what you think about Bondi and what's going on in LA, because I've been very generous in giving her the benefit of the doubt. I've been attacked for that a lot from a lot of people who just don't like her. And I can completely understand that. I don't like a lot of things that she did, particularly in Florida, going back to the Parkland bill. She seems to be saying all of the right things lately. But what she's saying is the same things we've heard from Democrats and Republicans for years. We're going to investigate you. And then guess what happens to that investigation? We never hear about it again. We don't know what occurred. So she's investigating the LA County Sheriff for delaying permits. And the left is going crazy saying, look, she's trying to upend years of history here. Well, yeah. That's what we're trying to do, is upend years, you denying the constitutional right to keep and bear arms. It's bad enough you require a permit. It's even worse that you're delaying. And there's over, from what I understand, you might have a different number, but I believe it's over 4,000 that are sitting and waiting now. And of course, he's just saying, the sheriff's office is just saying, well, we're understaffed. Bondi comes out, says the right things again. So my question is she out over ahead of her skis again on this, talking a big game, saying the right things, and then this is just going to get, flushed down that investigative tube that we never see a result of? I don't know.
I certainly hope not. I mean, listen, I will say this. The fact that they're using the Civil Rights Division to investigate potential abuse of the right to keep and bear arms, that alone is newsworthy, right? Because we've never seen that before. And I think that's so appropriate, because again, we are talking, as you say, we are talking about a civil right. So that step, I think, is a great step. Now, as you say, what happens to that investigation, I think, is something else entirely, right? I think it's going to be really easy for the sheriff to pass the buck onto the supervisors and say, listen, we're doing the best we can with the money that we've been allocated. I'm not sure I buy the same day that Bondi announced that investigation, the LA Times had a story about how the Los Angeles Sheriff's Department is not getting inmates to court on time because their bus fleet is falling apart. And again, the sheriff says, look, we've asked for money. And the supervisors, they don't give us the money we need for new buses, but they do give them some money for transportation. It's just the sheriff's department has spent it on, new patrol cars, SUVs, things that they haven't spent it on buses. So there is budget, for administrative positions in the sheriff's department. How the sheriff chooses to allocate that money is kind of up to the sheriff, right? So I don't think it's just a matter of we're underfunded. That might be part of it, but you can reallocate resources in order to comply with these statutory deadlines that you have.
That's just an excuse. As many sheriffs as I do. I've got a lot of friends that are sitting sheriffs right now across the country. And I can promise you, viewers, that if the sheriff wants that budget reallocated, it's reallocated.
Yeah.
Hey, guys, we've got the DOJ, the Attorney General of the United States, on us for a civil rights violation right now. It's time to reallocate some of this budget. Let's move from equipment. Let's move from whatever it may be over here and put it over here and get this taken care of. We don't want this to drag out. Why? Because the taxpayers are going to have to fund this, and we don't want the taxpayers having to fund any more than they already do.
Right.
But that's not happening in LA. So again, smokescreen. That just shows me smokescreen.
Yeah. So, I think the next thing is I want to see some follow-ups here, right? So you've got in that lawsuit, and Bondi said that the LASD, CRPA versus LASD lawsuit was kind of what brought this to their attention. Well, it wasn't just the Los Angeles Sheriff's Department that was sued, right? The city of Laverne, California was sued for its excessive fees, charging 4 figures to get a concealed carry permit. You've got similar delays going on in New York City, where the NYPD is not even saying how many permits they're issuing now, but you've got delays of well over a year. And again, it's going to cost you 4 figures to get that concealed carry permit in New York City. So I want to see an investigation open up in New York City. I wrote about this over the weekend. Santa Clara County, California, again, a 4-figure cost to get your permit to carry. Hawaii, you've got some real issues with, right to carry. They don't have a process by which non-residents can get a carry license. So there's basically your right to keep your arms stops if you are a non-resident when you visit the state of Hawaii. And even the U.S. Virgin Islands, Mark, there was actually a lawsuit that was filed, I think, last week, again, dealing with right to carry reciprocity issues. There's a marina owner who I guess lives part-time in the Virgin Islands. He's got a concealed carry license in Washington State that's not recognized by the U.S. Virgin Islands. And he went to get a carry license, and they said, well, you got to have a Virgin Islands driver's license. He's like, well, I don't live here long enough to get a driver's license. So, and then they eventually said, okay, you can apply for a permit, but you can't register this gun, because Virgin Islands, you have to register a firearm because it's a quote unquote assault weapon. So he's challenging that as well. Again, there are no shortage of places for the DOJ Civil Rights Division to investigate. So I don't want to see this be a one-off, right? To me, that's the biggest thing. I want to see some follow-up, not only with this particular investigation, but I want to see more jurisdictions that are abusing our Second Amendment rights get put under the microscope as well.
You mentioned Hawaii. How long has the Young case been going on in Hawaii?
Oh, Lord.
I've lost count how many years it's been.
Yeah.
It shouldn't take this long to do these things. It angers us. And a good example of that is how we've come full circle with carry permits altogether, now moving towards constitutional carry. As you well know, North Carolina is on the very cusp of becoming the 30th constitutional carry state. Florida, remarkable to me, is having so many problems down there regarding Second Amendment issues. DeSantis has made it clear, repeal this, let's get rid of red flags, let's get rid of the 21 and under ban. or 20 and under ban, 18 to 20. Let's repeal that. Bring me an open carry bill. I'll sign those bills. And you've got a Republican supermajority that is standing in the way in the state of Florida for whatever reason. Usually that means this. There's money somewhere. You can always follow the trail, the money trail in politics. I don't have any idea what's going on in Florida. But, we had to go through, just much like Biden, we had to go through the previous 4 years to look over our shoulders and go, whew, what the heck just happened, right? We go through, since 1987, all these permits. Now you've got constitutional carry. People are beginning to realize I shouldn't need a permit to carry a firearm. And we've got the majority of the states moving in that general direction. So, but it's taken far longer for that, okay, than the 4 years of Biden. At least we were to end that at 4 years. This has been going on since 1987 from a permit standpoint. And you got people like Young spending gobs of money, fighting this through local district courts up through appellate courts. It's nonsense because we are talking about a constitutional right, very plain and simply written, 27 words in the U.S. Constitution. And who is in the way? Democrats. So you talk about, we'd like to see this case in New York. 4 figures to get a permit in New York. Maybe that's not a lot of money if you live in New York, depending on the cost of living. I don't live in New York, so I don't know. Oh, it's only going to cost me $1,500 to get a permit. I pay $9,000 a month in rent. That's nothing. Who knows?
Right.
It shouldn't cost us anything. It should cost us nothing to carry our firearm. Simplest way to end this, Democrat Party, last I checked, was at 28 or 29% approval. If we can get them down to 0%, rid the nation of the Democrats, we're not going to have any more problems. So maybe that's the route we should take. I don't know.
All right, listen, Mark, I always enjoy our Monday conversations. Thank you so much for being a part of the program today. And 1 week closer to seeing you in Atlanta at the NRA annual meeting. So less than a month away now.
Forward to that. Hey, guys, come out and see me and Cam. We're going to be there in Atlanta at NRA. If you're there, come shake our paws, man. It'll be a lot of fun.
Absolutely. All right, Mark. We'll talk to you soon, man.
Brother. You bet.
And thanks to Mark for joining me on the program. By the way, I know tomorrow is April 1st. We don't do April Fool's Day here on Cam and Company or at Bearing Arms. In fact, I despise it when media outlets decide they're going to have a little fun with April Fool's Day. If you want to be taken seriously the other 364 days out of the year, you don't play jokes with your reporting on April 1st. So if you see anything tomorrow at the website or here on this program that makes you say, what, really? Yeah, really, unfortunately, because I'm not going to be playing any tricks on you. All right, let's turn now to today's Armed Citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Illinois. Maybe not. Well, actually, I guess this is a recidivist incident because this individual did have a previous criminal history, not involving firearms, but he was under the radar of law enforcement. Here's the headline. Probation for man who fired gun multiple times outside of Beach Park home where children were inside. Now, that's kind of a mouthy headline, right? And there was no allegation that Jesus Machuda Barragan, age 20, actually aimed his gun at the home where children were inside. If prosecutors have been able to prove that, then perhaps maybe he would have gotten more than probation. But he was charged back in December with 3 counts of aggravated unlawful use of a weapon, as well as reckless discharge of a firearm, stemming from a shooting that the Lake County, Illinois sheriff responded to around 10:30 back on December the 5th in Beach Park, Illinois. When deputies arrived on the scene there, they learned that Machuda Barragan, who lives there at the home, had been in an argument with an acquaintance who also lives there at the home. He had left the home, Machuda Barragan did, before the sheriff's deputies arrived. According to Lake County Sheriff's Office Deputy Chief Christopher Cavelli, the suspect, before driving away in a vehicle, fired a gun multiple times from the car. Cavelli said at the time it's unclear why or where Machuda Barragan was shooting, as no bullet holes were located. But they knew that he discharged the firearm. He was taken into custody by a police officer in Waukegan, Wisconsin. Found to be in possession of a pistol. Sheriff deputies located a second gun in his vehicle along with the 5 spent shell casings. Again, there were small children inside the home. Sheriff's Office notified the Illinois Department of Children and Family Services about the incident. At the time, Machuda Barragan also had an active warrant for failing to appear in court for a DUI case. So the state's attorney's office filed a petition to detain Machuda Barragan in custody while awaiting trial. because you have to do that in Illinois now, right? Even if you are assumed to be a danger to the community, prosecutors actually have to request that somebody be held, and a judge can say no. In this case, and by the way, in Cook County, Mashuda Barragan would have been let go. Maybe an ankle monitor put on him, but maybe not even that. Just, show up in court again. In Lake County, he was ordered to be held until trial. And he entered a negotiated plea deal with the Lake County State's Attorney's Office on Monday, pleading guilty to one count of reckless discharge of a firearm, which is a Class 4 felony. In exchange, he received a 12-month probation sentence, 180 days in jail, but because he had spent 110 days behind bars awaiting trial, and you get basically a day off your sentence for good behavior, that 180-day sentence was completed immediately, and Mashuga Barragan released from jail. Ordered not to consume illegal drugs or alcohol, not to possess firearms, had to complete 100 hours of public service, and submit to a random substance testing. All in all, I'd say, honestly, a pretty lucky break. And no word, by the way, on what happened to the DUI case. I guess maybe that is still ongoing. But, yeah, quite the gift that the criminal justice system gave young Mr. Mashuga Barragan, excuse me. And I guess for his sake, I hope he takes advantage of it. On to today's armed citizen story, which actually happened about a week ago. I got to confess, I heard nothing about this at the time. This is one of those stories that you would think would get some national news attention. Like, I understand, somebody breaks into a home in the middle of the night, homeowner defends himself or herself. It's kind of cut and dried. Maybe there's not even a lot of information available right on at first glance. I understand why those stories tend to remain local. This headline, however, is suspected Hardeeville carjacker killed by armed citizen who protected himself, police say. That to me seems newsworthy enough that there would be some national attention. But no, not at all. So Hardeeville, South Carolina, this was last Sunday night. Police said a man was shot and killed near downtown Hardeeville in an apparent act of self-defense as he attempted one of, quote, several armed assaults in the area. So about 9:40 last Sunday, officers from the Hardeeville Police Department got word of an armed suspect who had tried to carjack a DoorDash delivery driver before he eventually fled on foot. According to the Island Packet newspaper, as police in Hardeeville were responding to that call, officers actually heard several gunshots nearby. According to Police Chief Sam Woodward, the suspect had fired several shots near the Econo Lodge Inn and Suites. Police at this point, or at least at that point, weren't sure whether or not there was a specific target in mind. And then he allegedly tried to commit another carjacking outside another motel there in the area, pointing his gun at the driver of the car, firing at least once. That driver, however, was armed and fired a number of shots in return. The suspected carjacker struck at least 3 times. Officers responded very quickly because, again, they were already in the area. They tried to perform life-saving measures, but the suspected carjacker was pronounced deceased at the scene. According to the Island Packet, the driver initially detained, but later released as police learned more about the incident, with investigators later saying that the deceased man was, quote, actively involved in attempted armed assaults on potential victims when he encountered an armed citizen who protected himself. The homicide remains under investigation. But again, at this point, everything is pointing to self-defense. Why, again, this story did not get any real news attention outside of Hardeeville, South Carolina is beyond me. But there you go. A carjacking guy who was basically on a crime spree, stopped by the victim who was able to protect and defend himself. Finally today, our good deed of the day. In the right place at the right time, willing and able to do the right thing. A teenager from Cleveland, Ohio named Tyler Soden, who was able to save a family from a house fire. This was last Friday morning, about 11 o'clock. Fire crews dispatched to a home on the west side of the city. Witnesses had reported smoke called 911. Firefighters on the way there, but 16-year-old Tyler Soden couldn't wait. According to Lieutenant Mike Norman, who's a spokesman for the Cleveland Fire Department, Soden heard screaming, looked out a window, saw smoke, and then ran and grabbed his ladder, ran to the house. He found 3 people, a mom, her 7-year-old child, and a 10-month-old baby, who were there on the roof above the front porch. And Soden placed his ladder up against the side of the house, climbed up, helped all 3 individuals get down safely. He told Fox 8 in Cleveland, I don't know what was going through my head. He said, I'm glad my dad told me how to use a ladder. I am too. Not as glad as the mom and her kids are, I bet. According to Fox in Cleveland, I think this was Fox 8, a couple of Cleveland police officers named James Bellamy and Kerry Adams also just happened to be driving by. They had, I guess, gone to pick up lunch, and they smelled smoke. They actually got there, too, before the firefighters. They got out of their car. They helped an elderly man and a dog leave an adjacent home that also suffered damage from the fire. About $170,000 in damage to the main house, $10,000 in damage to that adjacent house, 7 people displaced from the flames, but again, no serious injuries. Thanks in large part to the quick thinking and fast action of Tyler Soden in the right place at the right time, and of course, willing and able to do the right thing to save some strangers in need. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you, as always, for being a part of the program. I'm looking forward to seeing you back here again tomorrow. Be sure to check out BearingArms.com throughout the day. We are keeping you up to date on all of the latest Second Amendment news and information. Probably not anything new on Snope, but who knows? Maybe we'll get word of another DOJ civil rights investigation into Second Amendment abuses today. You never know. Regardless, we've got you covered, and we certainly do appreciate your support. In fact, if you like what you see, I would encourage you to become a VIP Gold, or VIP Platinum member. You'll get exclusive content and other goodies at every level of support, but you will also be helping us continue to produce the independent pro-Second Amendment journalism that we're doing at Bearing Arms. And your support is greatly appreciated, and it is greatly needed as well. So thanks again. All right, we'll see you back here tomorrow for 2A Tuesday. Until then, be well, be safe, and be free.